Hey guys, I'm back with a couple more things that you should have gotten in your high school government class if your teacher was doing their job, or if you graduated sometime before the 70s and 80s, then it's possible these court cases came after your time. And, well, you should have learned them on your own through the news. So let's talk about free speech rights of the media. Very hot topic right now. Does the media have to cover these things? What can they choose sides? Can they manipulate? Well, let's look at a bunch of Supreme Court cases and see what we got going on. I do want to take a second to say there's no students on campus today, so you don't have to worry about this. All right? There was no students involved in hugs today. All right. So let's go to 1804. We've just had the Revolution of 1800, as a lot of teachers like to talk about, the first peaceful transfer of power between political parties. The Federalists, George Washington, Hamilton, and the boys, have lost, and Thomas Jefferson and the Anti-Federalists have come in, and they're going to abolish the bank and all this other kind of stuff. And it's a pretty hot topic, and I think if you've seen the musical, you know that this will eventually lead to Alexander Hamilton getting shot, right? Yeah, he did throw away his shot. So we're in 1804, we're running for re-election for Thomas Jefferson, and Harry Croswell was convicted for libel for printing a story critical to Thomas Jefferson. But the problem is the story was true, but he was bad-mouthing the president. Can you print true stuff bad-mouthing the president? And the Supreme Court ruled that New York must change its laws, in this case, to permit truth as a defense. If it's true, no matter how unappealing it is, no matter how close to an election, how about them apples? Yeah, you can print it because it's true. What's the point of having a free press and freedom of speech if you can't speak the truth, right? So let's move on down a little bit more. We have Neer versus Minnesota in 1931. What can we actually print? Now, there's a legal term called prior restraint. Prior restraint means you can't write that. No, you can't put that in the media. Prior restraint says the government can tell you what you can and can't print. I think this is going to be a pretty obvious outcome for a court case for you. State laws allowing prior restraint was unconstitutional, and this decision was also extended to protection of freedom of the press to states, to the 14th Amendment. If the federal government cannot block you from printing things, the 14th Amendment allows the same freedoms to people in the states. It's another one of those constitutional things. 14th Amendment said, well, originally the Constitution only applies to the federal government. So each state started banning citizenship, started banning voting stuff, started regulating all these other things. Well, the federal government can't deny your rights, but it doesn't say anything about me. So the 14th Amendment comes around so that states cannot discriminate against, in this case, the newly freed slaves, the now freedmen. We can't block them from becoming citizens and stuff like that. Because if the federal government outlaws it, then you got to outlaw it too. So if the Constitution says you have free speech, you got free speech, and the states can suck it up, right? All right. So prior restraint, that's a really big legal term. Can I really print that? Yeah, you can print that. Well, what if I print stuff and it's damaging? Do I have to pay for the damages? Let's look at some other stuff. New York Times versus Sullivan, 1964. Martin Luther King Jr. is in prison in Birmingham for perjury, for committing perjury in Montgomery, Alabama. We're not real sure if he really did that or not, still a little on the controversial side. But anyway, an ad was run in the New York Times that was saying that he was only arrested to stop his civil rights movement. And several people had sponsored these ads and were running them around the country trying to deface Montgomery, state of Alabama, and all of that, and recruit people to come over to the side of the civil rights movement and Martin Luther King Jr. So Montgomery City Commissioner L.B. Sullivan filed a libel action against the New York Times for this ad and against 4 black ministers listed as endorsers of the ad, claiming these allegations were untrue and defamed him and the police personally. You're making me look bad. All I'm doing is my job, and yeah. The court held the First Amendment protects the publication of all statements, even if the statements are later proven false, as long as they were done in good faith at the time they were published. So one of the key things in the case that Sullivan was appealing was some of the things in the ad was wrong. They believed it to be correct at the time, but Sullivan knew it to be wrong, but that had not come out and been proven yet. The court held that the First Amendment protects the publication of all statements, even those later proven false, about the conduct of public officials, unless they're made with, quote, actual malice or knowledge that they're false or reckless. Now, if I just make crap up and start slinging it at an opponent through the media, that's wrong. But if an anonymous source told me that it was true, and I have every reason to believe that it's true, I can go ahead and publish it so people can get discussing it, and we can throw it out there in that open marketplace of ideas and start swapping things around. That's the key to the First Amendment. The community has the right to discuss these things and seek out the truth. Makes it tough in an election year, doesn't it? We don't have to prove it true first. We just have to believe that it's accurate. And if malice is involved, it's your job to prove malice on my part. Because in the courts of law, I'm innocent until I'm proven guilty. You have to prove I did it just to be mean. See where we're going with some of this stuff? Let's do another one. Gertz versus Robert Welch, 1974. You got an anti-communist magazine. It was the John Birch Society, I believe it was. And they were saying that the police were not doing their job and they were allowing these different people, that police officers were targeting people. A lot of the stuff that we have going on now, history just repeats itself. Yeah, Gertz sued for defamation because people were saying that he was framing individuals and, this prosecutor was corrupt and this kind of thing. A lot of the stuff that you hear now, right? And the court ruled 5-4. A private person does not have to show actual malice in order to prove libel. Gertz said, man, I just want to go back to being anonymous. I'm not a public official. I'm just here. Even if the defamatory comments concerned public issues. Let me do that again. The court ruled 5-4 that a private person doesn't have to show actual malice in order to prove libel, even if the defamatory comments concern public issues. The Supreme Court distinguished between public and private individuals for the purpose of the defamation law. Private individuals are people who don't really hold public offices. They're just out doing their thing. They're the teller at Wendy's who messed up your order, and you're like, well, they're a racist. I'm not a racist. I just screwed up your order because it's Wendy's, right? They're paying minimum wage. You're going to get minimum service. Hope that wasn't offensive to anyone. If it's something you campaigned for and ran for, like a city council position, you're open game. If it's the president, you're open game. We can say what we want. But if you're just a private individual doing your job, here's what the Supreme Court said. Here's the quote. Private persons are more vulnerable to injury, and the state interest in protecting them is correspondingly greater. So these guys can sue for damage if you are putting lies, defamation, stuff like that in your articles. Got to be careful with them. Public officials with a public platform, fair game. Let's move down some more. Garrison versus Louisiana, 1964. A Louisiana law that published true statements made with actual malice sends someone to jail. It goes to the Supreme Court. But it was true. But you did that out of actual malice. Like you brought that out to hurt me. And it was sure it's true, but like let's say, for example, it happened 50 years ago. Okay, so that happened. Why are you bringing it up now? Well, just to defame you so I can win the election. But it's true. Well, let's go back to what we had before. The only time you can sue for libel is if there is, quote, reckless disregard for the truth, end quote. If you did it, you did it. And it's fair game at any point in your life. Yeah, which is what keeps a lot of the people out of office and why my wife has begged me, please don't ever run for public office. If you do, don't mention my name. All right, so that's Garrison versus Louisiana, 1964. Let's skip on down to New York Times versus United States, 1971. Most people know this as the Pentagon Papers. And in the Pentagon Papers, what we had was President Richard Nixon has been looking into the Vietnam War, and some people within his cabinet who apparently don't care for him very much have taken some classified documents, for your eyes only style documents, or no, it was highly classified. Then you have top secret, for your eyes only. Yeah, highly classified documents about how the different presidents, starting with Truman right after World War II, had gradually escalated the American presence in Vietnam, setting us up for this war, and how the whole thing was almost planned out to drag in for a political statement to fight the communists, and it was nothing like what we've been told on TV. You had the Leidy Gulf, where we shot our own ships and stuff, allegedly. And so New York, someone in Nixon's cabinet gets a hold of this and leaks it to the New York Times. Well, the New York Times is going to publish it. The United States will sue the New York Times for prior restraint. Hey, man, you can't publish that. People are going to get hurt. There's going to be rebellions. Our troops will be in danger. Other countries may jump in. You cannot print that. And the Supreme Court will rule, yeah, you can print it if it's true. But it was top secret. It's illegal for you to know this. Well, it's true. And it got leaked out. And any damage being caused, according to the Supreme Court, would come from other entities, not the person revealing the truth. So if someone else takes the truth and decides to jump in and cause damage, that's not your problem. That's different from inciting a riot or something like that. According to the Supreme Court, if we can get these secret documents from the government and put them out there, WikiLeaks, then it's constitutionally protected. How about them apples? All right, let's go to Nebraska Association versus Stewart, 1976. What about media publishing stories with only half the truth? What if it's an ongoing thing like Joe Biden's laptop, or when President Trump was about to go into office, and Russian collusion? Should they wait until the facts come out, or could they print just the first thing that hits the airwaves? A judge's order that the media not publish or broadcast statements and a murder trial that was going on was ruled unconstitutional. You got a murder trial, and if we start throwing these things around before the judgment, before all the facts are presented, this could very well taint the jury, and this could deny this person a fair trial, right? Or deny the victims fair justice. Supreme Court ruled, the opinion was written by Chief Justice Warren Burger, reason that, quote, the whole community should not be restrained from discussing a subject intimately affecting life within the community, thus protecting the press's responsibility to provide information of public interest. So that was Nebraska Press Association versus Stewart, 1976. You don't have to have the whole story. You can get just a snippet. You can have an anonymous source, which was your dog or your parakeet, as long as you're bringing it out without provable malice and reckless disregard for the truth, for the obvious truth. You can go ahead and start running these stories and let us talk about it ourselves. And you can start running analysis and opinions, and you can convince us of what we should feel, but feelings are not the truth, right? Okay, let's jump down to another one. Hustler versus Falwell. How far can they go with printing these things, these public figures? How far can we go to attack them? What's his name? The guy who ran Hustler. You know, he was in a wheelchair. His name eludes me, and I'll think of it as soon as I turn the video off. He ran a very vile picture of Jerry Falwell doing not so wholesome things with his mother in Hustler magazine. And it was a cartoon. It was a satirical thing. And Jerry Falwell was like, oh, this is ridiculous. I can't put up with this. So Jerry Falwell will sue, right? Larry Flynt, that's the guy's name. Falwell will sue Larry Flynt for defamation and all this kind of stuff. The Supreme Court will rule, unless the publication contained a false statement made with actual malice, you can't do that. And we all know Jerry Falwell was a pastor. He was a very outspoken person on things like that. He was opposed to Hustler magazine and all. But the thing is, it was wrapped in a cartoon and put in a comics format section of the magazine. So it was obviously meant for entertainment purposes and not to be taken seriously, is what the Supreme Court ruled. if it's obvious satire, if it's clearly joking, if it's the Babylon Bee, if it's bustatroll.org, or some of these other online magazines that just throw out crazy, crazy stuff, as long as they label it, this is purely satire and for entertainment purposes, that's fine. And if you believe it, that's your fault. You're supposed to check your sources. Any responsible adult is supposed to check their sources before they repost these ads. Yes, they're totally legal. Now, if Facebook or Twitter or somebody wants to block the reposting of those ads, that's their business. It's a private platform, and we covered that on an earlier video. If it's clearly satire, you can't do it. All right. Brandsburg versus Hayes, 1971. Should reporters be forced to share confidential information? Do they really have privilege where they can hide their sources and hide it? No, they don't. According to the Supreme Court, no, they don't. The spousal privilege is a legal term that's respected. Your spouse could not be forced to testify on something you did because two became one, and that you can't be forced to testify against yourself. That's the Fifth Amendment, no self-incrimination. And so your spouse is a connection of you, right? Now, your lawyer cannot be forced to testify against you. That's client-attorney privileges. That's off the table, because how are you going to get legal protection if you can't be honest with your attorney? A reporter, on the other hand, it's different. This whole thing about protecting your sources, that's within the industry. That's so that they can get better stories and publish the Pentagon Papers and stuff like that. Supreme Court found that this so-called reporter's privilege does not apply if a reporter's confidential information was of, quote, compelling and paramount state interest. So if the Pentagon Papers are leaked out to you, and we say in court under subpoena, who told you that? And you say no, you were open to the legal, you are now an accomplice to breaking the law and releasing the classified information, and you get what's coming to you. All right, however, Cohen versus Coils Media, 1982. Cohen's claim, let's see. Cohen is a Republican campaign associate, a 1982 Minnesota gubernatorial candidate of Wheelock Whitney, and he will release some records on the Democrat candidate in order to help sway the election. All right. The newspapers had promised him confidentiality. Hey, man, if you give me some dirt on this guy, I swear we'll keep you private. But once he released confidential information, the newspaper outed him. They said, well, we got it from him. They promised to keep him anonymous, but they broke their promise. This was not under court order or anything else. They just printed his name in the paper. The guy's fired for breaking policy and stuff, rightfully so. His reputation is ruined. He's not going to get a job around here anymore. We can't trust you in public records and stuff anymore. So he sues the newspaper. Hey, man, you broke your promise. You owe me damages removed. Now, remember, reporters can be persuaded in court. They can be forced to testify. But these guys just outed him. Are they protected? No. Supreme Court tackled the question of whether the First Amendment bars a source from recovering damages if a newspaper doesn't fulfill its promise of confidentiality. And the Supreme Court said the First Amendment does not protect the press. If they promise you they're not going to say anything, and they trick you and they do it, sue the crap out of them. We have a case about to hit the media right now. Not many people are talking about it, but you just wait, it's coming. Where Rudolph Giuliani, the guy who outed Hunter Biden's laptop, all that kind of stuff, he was called into an interview. And the interview was set up at a hotel. And this woman interviewer was like, hey, let's go back to my room because I got all the cameras and stuff set up in there. So he walks in and all the cameras are set up. And she offers him a drink. And she offers him a massage and all this other stuff. And he quickly realized something's going on, right? So he's like, oh my gosh, I need to, according to his story, I need to look good. So he leans back to tuck in his shirt. And as he does that, Sacha Baron Cohen comes busting in the room. Oh, you're hiring prostitutes. And tries to frame him, saying that he went up there to be with prostitutes and stuff. And he starts saying the reporter is a minor and you have brought minors into a hotel, and totally sets him up like this, right? He's called the police and expect to sue the living crap out of Sacha Baron Cohen. Can he? Well, sure, if it was under false pretenses and it was a setup, Supreme Court says yeah. A, it was false. B, it was done with malicious intent. Clearly wasn't satire. It's going to ruin your career and all your reputation and stuff. And we promised you one thing, and we promised you not anonymity, and we gave you something different. We're going to make you famous for it. Oh yeah, total lawsuit coming up on that one. So anyway, I hope that helps you understand a little bit about the press and what's going on. How do they get away with false stories? How do they get away with anonymous sources? How do they get away with half-truths, half-stories? Because otherwise, what would we have to talk about? And as funny as it sounds, that's what the Supreme Court looks like. Otherwise, what would we talk about? We have the right to free exchange of ideas. And among us, this is how, debating these things back and forth, this is how we establish what's right and what's wrong. This is how we come up with what do we expect, what protocols we want to follow, what behavior do we expect from our government and our media and our people and our communities. This is how freedom works under the Constitution. It's ugly, but it works. All right, y'all, take care.